Morning everyone, welcome to our event relating to the Schrems decision. For those of you who've joined us before, you'll know that during lockdown we've done some panel discussions which have been quite informal in terms of looking at data protection issues. Today is going to be a little bit more formal with a little bit more presentation, and that's simply because there's quite a lot to get through and some aspects of it are quite complex. That's not to say that we're not going to be taking questions. We're more than happy if you submit questions during the presentation, and we're certainly hoping that we'll have time at the end to take Q&A then. So please use the Q&A rather than the chat box if you want to submit questions so that we can see the questions as we go through. You'll see that in the Q&A box there's also a link to a feedback survey. If you could take the time to fill in the feedback survey, that would be fantastic. So moving on to the next slide, just to let you know who's going to be speaking today. There'll be me. I'm a partner at Owen Mitchell and I specialise in data protection, and also Lauren, who's an associate in the team who also specialises in data protection. So moving on to the next slide. So certainly from a data point of view, last Thursday was a very big day for us, although to be honest data protection lawyers don't get out much, so you know, make that what you will. There was a decision of the Court of Justice of the EU that we've been waiting for quite a long time, relating to what's known as the Schrems 2 case. And essentially what that case relates to and what we're going to be talking about today is the compliant export of personal data outside the EEA. And certainly I think it's fair to say that the Schrems 2 case has put the cat amongst pigeons in relation to the export of personal data from the UK and the EU outside the EEA, and primarily in relation to export to the US. So in a nutshell, what the court has done is it has invalidated the EU-US Privacy Shield, and it's also put additional requirements around standard contractual clauses, which are standard clauses which are approved by the Commission relating to the export of personal data. So what we're going to do is we're going to have a look at first what are the or were the mechanisms pre-Schrems for exporting personal data outside the EEA, what the court has said, and most importantly what the practical impact of that decision is going to be. Now, as you'll appreciate, it only happened last Thursday, and so there isn't definitive guidance from either the ICO or the European Data Protection Board at the moment as to what that might be. There have been holding statements. And so there might be some things that we're going to have to say we don't know, or that we're waiting for guidance. And I think one of the takeaways I would say in relation to this is that what is being said by the data protection authorities is going to be important, and it's important to monitor what they're saying, because there is likely to be a flurry of guidance in the coming weeks. Hopefully it will be pretty soon, because I think there's a lot of people that aren't quite sure what they're meant to be doing at the moment. The other thing that I would make the point on is that this Schrems decision is pretty important from a UK perspective for UK businesses, because if we exit essentially following the transitional period, if Brexit when Brexit happens on 31st December, if we don't have a deal, then we could be in the same position as the US, and so all of these discussions could be very relevant to the sending of personal data from Europe to the UK. But we're going to have a look at the Brexit implications later, but I thought it's just worth flagging that it is particularly important from a UK perspective. So in terms of a quick refresher on where we were pre-Schrems, as you'll see from the slide, you could export personal data from the EU to all countries within the EEA, so the EU and a few other countries, without any controls. It was regarded as fine because everybody were meant to be applying the same controls and protections in relation to personal data. The problem arises where you're talking about countries outside the EEA. And if you want to send personal data to countries outside the EEA, then in order to be able to do it in a compliant way, you've got to jump through certain hoops. And I think there are three main ways to do it. Either the country concerned or the organisation concerned, an international organisation, can have what's called a finding of adequacy, or there can be safeguards, or, and these are regarded as a secondary measures, there can be derogations, which are like individual exemptions, which we'll have a look at later. So having a look first, moving on to the next slide, at what's meant by adequacy. Essentially, certain countries have been considered by the EU to see whether or not they provide a suitable level of adequacy in terms of the protections that's given to personal data, the ability of individuals to get redress in the courts or to bring proceedings, and also the ability for national security bodies to access their personal data. And so all that assessment is done by the Commission, and the parameters of that assessment are essentially set out in Article 45 of GDPR. Now, in terms of adequacy, you can have a full finding of adequacy, so that all transfers to that particular country are okay, or you can have a partial finding. So you'll see on the slide that there is a list of countries where there is a finding of adequacy, and you'll see that there's a note next to Canada, and Canada's got a partial finding of adequacy, so it relates to commercial data rather than public body data in relation to Canada. And at the bottom, you'll see that I've referenced the US Privacy Shield. Sometimes people don't realise that the Privacy Shield isn't a whole separate sort of set of legitimising ways of exporting personal data to the US. It is a version of adequacy, and so it was a limited version of adequacy. And what Privacy Shield is essentially businesses and organisations in the US could self-certify under Privacy Shield that they would undertake to meet the requirements set out in Privacy Shield, and there would be an ombudsperson in the US in relation to issues that might arise if you were unhappy about how your personal data had been used in the US. So there was this sort of version of adequacy, but only in relation to companies and organisations in the US that had self-certified. So we're going to have a look at it, and as I say, unfortunately, depending on your perspective, either unfortunately or fortunately, depending on whether you are relying on it or whether you are a privacy purist, the Privacy Shield has now gone, which we will have a look at as what that impact will be later. Moving on to the next slide. Another alternative, as I said, is that if the country you're wanting to send the personal data to didn't have a finding of adequacy, you could put in place certain specified safeguards which were set out in Article 46. Now, I've just put a flavour of what those safeguards are on the slide because these are the most relevant to commercial organisations, and certainly the most popular one that people used were the and are the standard contractual clauses. And I think according to an IAPP survey, 88% of all data export outside the EEA is done on the basis of standard contractual clauses. I'll also potentially call them SCC during the presentation, as might Lauren. So if we refer to SCC as an acronym, we are talking about standard contractual clauses, which is again another name for model clauses, in terms of that was also quite a popular name pre-GDPR. And so what the model clauses are a set of clauses, contractual clauses, that essentially the exporter and importer enters into, and the content of it has been approved by the European Commission. And certainly it contains quite detailed provisions and obligations on both the exporter and importer of the personal data, although to my knowledge a lot of people, I know some people that didn't even read them before they signed them and use them as a sort of an export model. So that's another option if you're wanting to transfer personal data outside the EEA. And another something else which is quite useful if you can get it is authorization under binding corporate rules. That's where you have got corporate rules between group companies. So it's only useful for group company transfers, and essentially you agree the rules that will apply throughout the group for how personal data will be handled. They're quite difficult to get, and it's a very long-winded process. So then there's not a lot of group companies that have binding corporate rules, but it might be something that when we talk about the impact of the Schrems decision, they might become more popular, and it might be that, I don't know, the regulators, the data protection authorities have a look to see whether or not the process for getting binding corporate rules approved might be made slightly easier. I've mentioned two on the slide, which you might think is a little bit odd because I've put not yet in place. The reason why I've mentioned the possibility of there being an approved certification scheme or a code of conduct is that they are two things which have been referenced as being possible solutions to what's happened under Schrems, in terms of maybe that the EU will therefore rush through certification schemes or codes of conduct to try and improve what's been happening. So I have just flagged them there. They're not currently in use, but they are something which is a possibility. And finally, moving on to the next slide before I hand over to Lauren, is looking at the possibility of, if you've not got a finding of adequacy, or you can't use one of the safeguards in Article 46 of GDPR, there are what are called derogations under Article 49. And they're sort of like individual exemptions, and the recitals in GDPR certainly say that you shouldn't really be using them for long-term ongoing transfers of personal data. Their intention is more on a sort of ad hoc basis, but nonetheless they are there, and they may well fall under the spotlight following the Schrems 2 decision. And you'll see the sorts of things that are there. So, for example, you can get the explicit consent of the individual concerned, or if, for example, it's necessary that somebody wants a contract performing in America, for example, it may well be that their personal data has to be transferred to the US in order for that contract to be performed. Again, I've just put an idea of what those are up there. There are others that can be considered in relation to things like public sector bodies, but I thought it would be useful to give a flavour in the context of business organisations. So what I'm going to do now, before we have a look at the practical impact and what you might want to be thinking about doing as a result of the Schrems 2 decision, is I'm going to hand over to Lauren, who's going to have a look at, well, what did the court say in both Schrems 1 and Schrems 2. So I'm going to hand over to Lauren now.
Thanks, Joanne. I'm not going to go into too much detail, because obviously I think for most people watching, the main points they want to get to is what the impact is upon them. Just as a brief background, this all began in 2013 when the privacy activist Max Schrems submitted a complaint to the Irish DPC on the basis that, in relation to Facebook, because his personal data was being transferred to the States and stored in the States, he didn't believe that his privacy rights were being protected. So that eventually kind of went to the High Court in Ireland, which referred it to the Court of Justice of the European Union, and who in 2015, because of what had happened and what was in place at the point, said that safe harbour was invalid. This then went back to the High Court in Ireland and the DPC, and the DPC asked Max if he wanted to review his complaint, which then brought about the kind of next step that we're in now. If you can just go on to the next slide, which kind of brought in Schrems 2. So obviously Privacy Shield was entered into in 2016 as a kind of a replacement of the safe harbour regime, which had been declared invalid. In relation to kind of where we got to in the court case, DPC had issues then in terms of standard contractual clauses after kind of Matt Schrems had clarified his position and his complaint on the basis that Facebook was transferring to the States under SCCs. This then went back to the High Court for the question of whether the SCCs were valid. At that point, obviously, this dated back to a complaint in 2013, which at the point Privacy Shield wasn't in place. And my understanding is I watched a video with Matt Schrems last week commenting on it, and the actual Privacy Shield was introduced to this at the very last minute in the High Court case, with the barrister for Facebook essentially saying that SCCs are valid because Privacy Shield is valid, and obviously in terms of those surveillance questions, they were fine with Privacy Shield, which obviously meant that SCCs was valid. That then brought Privacy Shield into the case, and the High Court essentially referred 11 questions to the Court of Justice of the European Union, 2 of which referred to the point about Privacy Shield. In terms of whether it's valid, in looking at those surveillance issues, and also the question of the ombudsman. So the idea around Privacy Shield, would there be an independent ombudsman who would look at and kind of adjudicate if there's any questions in terms of surveillance. So if we can just move on to the next slide. As I'm sure you have probably all seen in the news over the past week, and all those kind of headlines, this then led us to where we are now, where the court determined that Privacy Shield is invalid, and they are essentially the only kind of place that can determine it being invalid. So that's why the High Court had to refer it to the Court of Justice of the European Union. The reasons behind it, so when Privacy Shield was set up, there was an element of understanding that there would be some surveillance, but it would be limited. And then obviously where we've got to now is the kind of points that were referred from the Irish High Court is actually to what extent is that surveillance limited, which the court found it wasn't, and then the kind of protections and the rights of the individuals if their personal data had been surveilled. The question in terms of the ombudsperson also was they were not sufficient, because in terms of where you are in the charter, they wouldn't necessarily, their opinion isn't considered the opinion of a tribunal. So that also fell as well. So then move on to the question in terms of SCCs. If we can just move on to the next slide. So in terms of SCCs, these were found to be valid still, but subject to certain conditions, which on the next slide there's a few conditions. So as Joanne's already mentioned, and we'll go into further in terms of the impact after this, is standard contractual clauses are but there's been quite a lot of kind of seen as it's a mechanism, and if you sign up to this, then that's all you have to do, just get both parties to sign. There's annexes to it where you set out specifics in terms of the relationship, and there's also importers' security technical abilities. And there has kind of been a practice, like practically, where people essentially sign up to it and then put it in the drawer and forget about it. There are a lot of contractual obligations, which essentially the courts have now come out and said you need to fulfil those contractual obligations. So what the court said is not necessarily anything new. It's saying that what's in there needs to be done. That being said, the kind of intention originally was that obviously standard contractual clauses are kind of a standard level, but now the judgment essentially says that it needs to be considered in terms of Article 45, which are the kind of adequacy level. So that's one thing to be brought into question. There's also in terms of saying that the Data Protection Authority, so here in the UK would be the ICO, need to look at and monitor the compliance with the standard of contractual clauses, and if they deem that in a particular transfer setting it's not sufficient, then they should act on that and suspend that transfer. So it would be more on a case-by-case circumstance. Obviously, that's going to be put more a burden on the regulator, and also it could lead to the difference in that, not the consistent approach which GDPR kind of foresaw, obviously not necessarily being taken forward if DPAs are taking different views in relation to this. So that's kind of a quick shot in kind of what happened in the ruling and where we are with the judgment. So I'll move now back to Joanne to discuss what this actually means and the impact of these judgments.
Thanks, Lauren. Looking at the next slide. So, as I said, Privacy Shield was a very popular way of legitimising the sending of personal data to the US. I think last count there were more than 5,000 US organisations who self-certified under Privacy Shield, and there were thousands of EU businesses who were using Privacy Shield on the back of that self-certification. So it was very widely used. So the fact that Privacy Shield is invalid does give rise to a problem to a large number of businesses. And certainly I think there is an element of frustration in the US that Privacy Shield has been invalidated by the Court of Justice. I think one of the things that has been discussed about it is, did it really need to be invalidated in relation to all transfers of personal data? So, for example, if the concern was in relation to the security organisations being able to access personal data, could you not have just invalidated it in relation to, say, communications data rather than everything? So, you know, if there's an app store game that's in the US and essentially all they're collecting is metadata relating to your playing of a word search game, is it likely that the CIA or NSA are interested in that? I suspect probably not. So there has been some frustration in the US that it has been completely invalidated rather than, and I guess sort of, you know, been completely got rid of, rather than a sort of more nuanced view taken of what could happen to it. And the Secretary of State for Commerce in the US has said he's quite unhappy about it. So what does it mean? Technically, as of last Thursday, Privacy Shield went. If you were exporting personal data on the basis of Privacy Shield to the US, then you should have stopped it as of last Thursday, whilst you found a new way of doing it, or you should have put an alternative way of exporting the personal data in place. Having said that, from a practical point of view, the ICO has said on its export of personal data pages not to panic and to wait and see, so that if you already have it in place, the ICO has said wait and see what we say in our guidance. And I suspect they've taken that pragmatic approach because, as Lauren said, we've been here before, because there was a precursor to Privacy Shield called Safe Harbour. That was invalidated. There was an awful lot of panic. I think the ICO have taken a pragmatic approach to say we're going to consider our position, and what we're going to do is think about what we're going to say to people. So from a UK perspective, the ICO has said just leave things in place at the moment. Certainly, I don't think that's been a consistent approach with all data protection authorities. And so if you have group operations in other countries, that may well not apply, and it may well lead to a fragmented approach across the EU. The European Data Protection Board hasn't said the same at the moment. They've issued a holding statement. They were, however, I understand, scheduled to meet yesterday and today to agree what their position is going to be on this and on various other things arising from Schrems 2. So fingers crossed we'll get some guidance from them fairly quickly. Some people are saying that it should be out by the end of the week. don't know, that would be great if it is out by the end of the week. But again, as I said at the outset, I think watch this space is going to be the watchword of this, in terms of making sure that you are looking to see what the ICO and European Data Protection Board are saying. And certainly we are going to continue to comment on the sort of things that are being said about this. In terms of what you should do immediately at a practical level, is I think you need to understand if you have been relying on Privacy Shield. It may well be as part of your GDPR compliance that you know exactly which arrangements are subject to Privacy Shield where you've used it. If you don't, then I think the first thing you need to do is understand whether you have got any export arrangements which rely on Privacy Shield, and note those, so that you understand the scope of your problem as a result of Privacy Shield being invalidated. The other thing that I will just say as well is that there was some confusion happening after this decision as to whether or not the invalidation of Privacy Shield only applied to the US, or whether it also invalidated export to other jurisdictions. As I said at the outset, Privacy Shield only validates export to the US, so it's not going to change the position if you're exporting to India or any other jurisdiction that's not the US. So moving on to the next slide, looking at the longer term impact of the invalidity of Privacy Shield. The first point is that the ICO has also made the pragmatic point, which is don't enter into any new arrangements using Privacy Shield. So if you've got any pending contracts and you were going to use Privacy Shield, don't just press ahead with them, because whilst the ICO has said you can leave in place current arrangements, what you certainly can't do is put in place any new arrangements relating to Privacy Shield. The other thing to bear in mind is both the EU Commission and US counterparts are keen to try and sort out something on Privacy Shield. They want to come up with something workable, because there is an understanding that the value of data export, I think it's somewhere in the region of around $7.1 trillion in terms of the export of personal data between the US and the EU. And certainly the statement that's been issued by the Commission is that they are working together. They don't feel that they have to start from scratch. What they feel they have to do is essentially change what's already there to meet the requirements of the court, and they feel that the court has given them some helpful guidance. I'm not sure what that helpful guidance is, but they do feel that they can reach a decision moving forward on Privacy Shield, which they feel will solve the issue. Although on the basis that one of the big issues from Schrems 2 is the ability of the US government in terms of security services to access personal data. It'll be interesting to see what the solution is they come up with that, because from a policy point of view, I suspect that level of potential surveillance is unlikely to be reduced. So, you know, hopefully they will come up with something workable. If not, I suspect we might be meeting again to talk about Schrems 3 in the future. So in terms of what it means from your point of view, is that essentially once you've worked out any personal data that you were transferring personal data to the US on Privacy Shield, is that you need to have a look at any alternatives that might work for you. And certainly when Safe Harbour was invalidated, the thing that most people jumped on was to put in place standard contractual clauses as an alternative. Now that's an interesting one, and there has been some interesting comment from the DPC in Ireland in relation to that, and I sort of agree from a logical point of view with the point. And what's been said by the DPC is that if the legal arrangements in the US, which allow for surveillance and that there's no real independence of the ombudsperson and there's no proper redress, mean that Privacy Shield isn't valid, if what you've got to do with model clauses and standard contractual clauses is have a look at the surrounding legal position in the country in conjunction with the clauses to make sure that people are getting adequate protection which is equivalent to section 45, then does that mean that that's actually going to work if you try and put standard contractual clauses in place for the US? Because you've still got the same problems with surveillance, you've still got the same problems in relation to not having adequate redress. So there is a potential for logically standard contractual clauses not to be an alternative with the US, because when you do the evaluation, the US arrangements could cause a problem, and you wouldn't come up with the answer potentially that people are getting the appropriate protection of their personal data. So that is something just to think about. And as I say, we've not had any concrete guidance on that, and it would be useful to get that. The other one is obviously binding corporate rules in relation to intra-group transfers, so within group companies. They are available, but as I say, they're not going to be quick. So as a quick alternative, FCCs can be done very quickly. Binding corporate rules can't be done quickly, but you might want to think about starting a journey on binding corporate rules in terms of sorting that out for the future. Obviously, you've got your Article 49 derogations, and one of the questions we've been asked is in relation to the transfer of personal data outside the EEA on the basis of the derogations, where you've got a contract, does the contract have to be with the individual? And there are two different derogations. The one I've mentioned, the contract does have to be within the individual. There is a different derogation relating to where the contract is with a third party and impacts on the individual, but the technical differences between the two, and I'm not going to go into them in detail, but for whoever's asked that question, it is worth having a look at Article 49 in relation to that. The other things which are slightly more technical or pragmatic, which potentially need to be thought about, is if you can't put binding corporate rules in place and you're concerned about standard contractual clauses, is looking at the personal data itself. Does it need to be transferred as personal data? Could it be anonymised? If you're going to be using it for statistical analysis, and in actual fact you don't need personal data, you only need anonymised data, it might be worth thinking about that, because obviously if it's properly anonymised and anonymised from a GDPR point of view, then it stops being personal data. One of the other things that could be thought about is looking at the arrangements in terms of where your personal data goes. Is it possible to keep it within the EEA? Because if you keep it within the EEA, you don't have these issues. But again, I appreciate that that might not be possible, certainly in all situations. As I say, these are ideas at the moment, and the issues relating to standard contractual clauses obviously are, potentially there. So I think watch this space, as I've said, is quite important in terms of having a look at what the European Data Protection Board, the ICO, and various other data protection regulators are saying is actually quite important. The final point I would make on this before we move on to sort of standard contractual clauses and the practical points arising from that is that it's unlikely that one size will fit all. It might well be the case that standard contractual clauses will help in relation to certain data transfers. It might be the case that some of the Article 49 derogations will help you in relation to some of the others, but I think it's a question of thinking about which one would be the most relevant. So by way of example, if you were planning on trying to use the Article 49 derogations in relation to employee data and you wanted to use consent, that probably wouldn't be the best bet, because you're not meant to be using consent in an employment situation. So that's what I mean by one size doesn't fit all, and to do an evaluation.
It's probably just as a final point, Joanne, in relation to those derogations are that the intention of them were only for kind of one-off or specific transfers as well. They weren't kind of put there to be kind of to replace or be allowed for continuous transfers. Just as kind of an additional point in relation to that.
No, that's absolutely right. I think when the courts have referenced Article 49, it's not a solution, it's not a long-term solution and shouldn't be seen as a long-term solution. Moving on to the next slide, in terms of the impact of the Schrems decision in relation to standard contractual clauses. As I think I mentioned, essentially standard contractual clauses are very widely used, and around 88% of export of personal data is done on the back of standard contractual clauses. And it certainly did used to be the case, as I think both Lauren and I have said, that they were printed off, topped and tailed, put in a drawer, and nobody ever looked at them again. That's certainly gone. You now have to look, as Lauren said, to see whether or not you can use standard contractual clauses by looking at the package, looking at the contractual obligations in the clauses, and also having a look at the surrounding legal system in the country that you're exporting to. And when you're sort of looking at the position, the legal system in the country that you are exporting to, you have to do an evaluation based on Article 45.2. And the reason I've referenced Article 45.2 is because that's the article that is used by the Commission to do an adequacy assessment in relation to particular countries. And so it has a long list of things which have to be considered, which look at, say, the data protection laws, looks at the ability for national security bodies to be able to engage in surveillance, looks at the ability of redress to individuals and things like that. There's a big long list of things. And the point I would make is that when the Commission is using those criteria to do an evaluation of a country from an adequacy point of view, it usually takes around 3 years, and it's an in-depth assessment. So turning around and sort of saying to businesses that they need to do their own assessment under 45.2, it strikes me that without guidance, that's going to be really, really difficult, particularly if you're trying to do it very, very quickly. To put something in place, maybe, you know, if you've got a problem under Privacy Shield and you need to put standard contractual clauses in place very quickly. I think it raises, from a practical point of view, if you are planning on using standard contractual clauses, what are you going to have to do? Certainly from a due diligence point of view, in terms of if you are planning, let's say you are wanting to use the standard contractual clauses because you're engaging a service provider offshore outside the UEA, and they're going to be getting access to your customer personal data, for example. What do you need to do from a due diligence point of view, and who should do it? The European Data Protection Board has indicated that the obligation to have a look at the package of standard contractual clauses in conjunction with the legal system is an obligation on both importer and exporter. It's not a question of just one of you has the obligation, it is both. But if you're exporting to a jurisdiction you are not familiar with, what you're either going to have to do is get the importer to give you the information that you're talking about, or you're going to have to take legal advice in the jurisdiction in terms of taking your own advice. And if you rely on what the importer's told you, you're going to have to be very confident that they are giving you correct advice in relation to this. It also obviously raises the point in terms of if you've got to do this assessment as to who's going to pay, because it will involve cost, particularly if, for example, you're going to have to take wide-ranging legal advice in a jurisdiction you're not at all familiar with, and whether or not from a contractual point of view you agree what the payment obligations, the cost obligations and implications of that are going to be. You'll see that one of the points I've flagged on the slide is the point I've raised already, in terms of there are already arguments that standard contractual clauses actually, if you have to look at them in the round with the legal system, can't be used in certain jurisdictions at all. the DPC has mentioned the US from a logical point of view if Privacy Shield has been invalidated, but are there other jurisdictions where there might be extensive state surveillance, which means that standard contractual clauses aren't available? Will, for example, the ICO or the European Data Protection Board issue a list of countries where they've got severe concerns as to whether or not standard contractual clauses will work? I don't know. Again, I think it's a question of waiting to see what's said, but it is something that does need to be thought about. The other thing that I would say in relation to standard contractual clauses is, for those of you who have been looking at them as part of your GDPR compliance programme, is that the standard contractual clauses that we currently have sorry, are those which predate GDPR. They've not yet been updated for GDPR. We are told that they have been reviewed, and I understand that the work had pretty much been done, but essentially they were holding back on issuing the new standard contractual clauses, waiting to see what Schrems said to see whether or not any adjustments needed to be made to the SCCs. So hopefully, if they are just about done and need to be tweaked in light of the Schrems 2 decision, then they'll be out soon. From a UK perspective, I think it does raise an interesting point in terms of, does that mean you therefore have to migrate onto the new standard contractual clauses? I think certainly in light of this decision, I would advise that you should. There was a thought at one point, and certainly I think it was pre-GDPR or just after GDPR, the ICO had indicated that they thought the standard contractual clauses, the new ones, would be very similar to the old ones. So their approach might be to let people keep in place the old standard contractual clauses. I suspect if they have been updated and have got to be updated to pick up the changes arising from this decision, that the ICO will now expect the updated standard contractual clauses to be used. But again, that's sort of my personal opinion in terms of there's nothing issued from the ICO at the moment following this to say what their position is going to be on it. But I do think it's something that's worth thinking about. So another practical impact of this will be is when the new standard contractual clauses come out, you will need to potentially think about factoring in putting those in place. I've certainly heard people say, well, it's just a papering exercise. I think that's not going to be the case on the basis, obviously it's a sort of reassessment and entering into new contracts, and certainly following Schrems 2, I don't think you can call the standard contractual clauses a papering exercise anymore. So that is something that I will just flag in terms of the new standard contractual clauses. So moving on to the next slide, I thought it would be useful to also put the Schrems decision in the context of Brexit. And as I flagged at the beginning of the discussion, it is a particular issue for the UK business. After 31st December 2020 in the transitional agreement, the UK will be very much a third country, as they call it, from an EU perspective, from a privacy perspective. And so we will be in the same position as the US or any other country outside the EEA. So if you have arrangements where, for example, you have a customer in the EU and they want to essentially send their data to you for you to be able to provide services in relation to it, then you need to think about how they're going to be able to send that data to you. So moving on to the next slide. If there is a deal, then the export of the personal data to the UK is likely to be picked up. So that if you do have a customer and they're based, say, in France and they need to send their personal data to you, then it will be caught by the deal. If there is no deal, however, and we end up with a no deal Brexit, then it does mean that hoops will need to be jumped through in order to export the data to the UK. And in terms of the likelihood of a deal by December, in terms of, I don't know, recently, I think in the press over the last couple of days, it's been saying that it's looking less likely. If there is no deal, what the UK has said is that they will be looking for an adequacy decision. So essentially what the argument is that they will want the EU to recognise that because essentially we're going to preserve GDPR after Brexit, and that we have the same level of protection as we did before Brexit of personal data, and therefore we should be given an adequacy decision. And if there's an adequacy decision, as I mentioned at the outset, we'll be on that list of countries and personal data can be exported to us without there being jumping through additional hoops. The difficulty with adequacy is that obviously it's not a quick process. I think I mentioned that it sometimes takes around 3 years for an adequacy decision to be made. The hope is that because we've implemented GDPR, that it will be a much quicker decision, but I think there's probably political issues around that, and whether or not there's political will to expedite it, I don't know. If you ask me to place a bet on it, I would say we will not get adequacy by the end of the year, but I may be wrong. Certainly the ICO's position is that they are monitoring the position in relation to Brexit negotiations and adequacy negotiations, and so certainly it is again watch this space in relation to that. If we don't get adequacy, where does that leave us? Well, it means that probably people will have to look at putting in place standard contractual clauses to send personal data from the EU to the UK. That then means that if, say, back to this customer in France who wants to send their personal data to you, they will have to look at the standard contractual clauses in conjunction with the system within the UK. So they will have to look at the data protections, which, you know, on the basis we have GDPR in place and the Data Protection Act 2018, that seems to be a nice tick in a box. I think the difficulty is, and certainly commentators have raised this, is that obviously we have a surveillance regime also, and the question mark is whether or not the criticisms that were levelled at the US in terms of not meaning that individuals got adequate protection as a result of the potential surveillance by national security organisations could cause a problem in terms of using standard contractual clauses for the UK. Again, I don't have the answer on this in terms of where we're going to be with this. And again, I think it is a case of watch this space. But certainly I think I can say that there was an assumption that if there was a no-deal Brexit and we didn't have adequacy, that there would be, as I say, this thing called a papering exercise, and people would put in place standard contractual clauses to bring personal data from the EU into the UK. As I've just said a few minutes ago, putting in place standard contractual clauses now is most definitely not just a papering exercise. It does involve quite detailed evaluation. So that will make life quite difficult. What I would say from a practical point of view is to understand where things stand and make preparations. If you have got important customers in France, be having discussions once it becomes quite clear what's likely to happen from a Brexit point of view, and whether or not we will get a deal, and plan for how you're going to be doing it. One of the things that has also been suggested is that if, for example, you are the data importer and you are providing services to customers in the EU, you might want to put a due diligence pack together for them to explain what the position is in relation to the laws in the UK, to try and make it easier. Obviously, you do need to be careful that you're not giving legal advice to them, but that has been suggested as being a way of securing business in relation to that. So unfortunately, as you'll see, the position isn't straightforward from a Brexit point of view, and certainly the sooner we get guidance from either the ICO or the European Data Protection Board, the better. The one sort of ray of light that you could argue in relation to Brexit is that it might be possible for there to be a UK-US privacy shield. The Swiss have got their own, and obviously the EU one has been invalidated, but it might be possible once we're post-Brexit, post the end of the year, for there to be a UK-US privacy shield. So that might make life easier for UK businesses that don't have group companies in the EU. But as I say, I think the Schrems 2 decision has sort of set the cat amongst the pigeons from a data export point of view, and I think it is something that unfortunately will evolve over the next few weeks. I think it's a question of waiting and seeing. I think we have got to a Q&A. We've got time for some questions in terms of looking at the time. So, Lauren, do you want to do some of the questions?
Yeah, so one of the ones that has come in is in relation to, obviously, the discussion has been about the surveillance issues in the US, and as you've mentioned there, after Brexit, after the transition period ended, that obviously the UK will be subject to those same kind of considerations. So someone's asked whether you need to consider the surveillance issues with countries within the EEA. So obviously at the moment, one of the reasons why the UK hasn't had this issue up to this point is actually that those considerations, whilst the court has the ability to assess outside the EEA, those kind of, all of these considerations are for that transfer when it goes outside the EEA, and are not kind of, it's two-pronged. So it's actually a consideration when it's outside the EEA, but it doesn't need to be considered when it's within the EEA. So I don't know if you have anything further to add on that, Joanne, in terms of actually questioning member states' surveillance laws from a GDPR perspective. It's not there, and to my mind, it's not within the court's jurisdiction to review that for member states.
I mean, I don't think, Schrems didn't consider it in terms of where other member states, they can send around to the other member states without considering those, and so they're not in the mix certainly for EEA to EEA transfers. When sort of beginning of next year, there has been a question mark over from a UK perspective, can we continue to send personal data to EU and EEA countries? And certainly the UK position at the moment, although it might change obviously post Schrems, is that you can continue to send personal data to the other EU countries, and there's not been a discussion about their surveillance laws so far as part of that. Whether or not that will arise after this decision, I don't know, and whether or not, if we don't get adequacy, whether that might be something that's raised in terms of by way of some sort of political leverage. Again, I don't know, but certainly the original statement and the position of the ICO on their website at the moment is post-Brexit, you can send personal data from the UK to EEA countries, and you don't have to do evaluations.
And to some extent, some of these questions are probably political rather than legal questions, because ultimately the same as the UK and the US, obviously questions people are saying, is this going to prompt a change in law in the US and everything, and obviously that's more of a political issue, so it is a kind of watch this space, and I know other people have kind of raised the issue as now that Privacy Shield has been made invalid, there are those other adequacy decisions for different countries that may have, since they were declared adequate, have changed their surveillance laws, and whether they're going to be challenged. Again, I haven't heard of anything of any particular countries whether they're going to be questioned, but also we don't know what's on the kind of agenda for the privacy activists. So unless you're aware of anything, Joanne, I think at the moment it's kind of, it just relates to Privacy Shield, and we don't know how it's going to progress from now in relation to other countries.
Yeah, no, I think as you say, there are a lot of policy issues and political issues tied up with this, and it will be interesting and obviously we can't really comment on those. It'll be interesting to see how those pan out from a US perspective, from a UK perspective. To be honest, it's a bit of a can of worms at the moment in terms of trying to tie everything policy and law together on that.
And then another question that we've had, which I know there has been quite a lot of commentary on it in the past week, is whether you could get around kind of the issues in relation to surveillance and put in place the SCCs if you do a risk assessment and assess that the area that you're in and the type of kind of work that you do isn't essentially subject to those surveillance requirements, or you haven't previously being subject to the surveillance requirements, or they've not kind of investigated you. So that's a question that's been raised, and also something that I know quite a lot of people have commented on. So it'd be interesting to hear your thoughts in relation to that.
Yeah, I think it's an interesting point, and there's a lot of people coming up with potential ways of improving the situation in terms of, so if you're doing the evaluation for standard contractual clauses, what's the position if you you use encryption or you use other methods of keeping the information secure? What could you argue that if you are merely transferring data in an area that the security services are not going to be interested in, can you say that you can ignore the surveillance laws in that country? I think the first point I would say in relation to that is that there is no guidance on that and on either point, and I think they're valid points that need consideration in terms of whether or not there are potentially technical solutions to improve the situation and mean that when you do your evaluation in the round of your standard contractual clauses, whether you can apply technical solutions to that. What I would say in relation to the point you've made about particular areas in terms of sectors is that, as I said, there was some disappointment in the States that the invalidity of Privacy Shield wasn't restricted to communications data. What happened in the court case when they thought about Privacy Shield was that they looked at what the law said. So if the law gave a potential for surveillance, then that was the thing that was taken into consideration, not whether surveillance would happen from a practical point of view. So in terms of dividing up particular sectors to say, well, our sector is not something that the security organisations are going to be interested in, therefore we can use standard contractual clauses, that's not the evaluation that was done under Privacy Shield. So if you sort of extrapolate what was said under Privacy Shield to standard contractual clauses, you being in a sector that the NSA is not interested in is not going to help. But having said that, it's not to say that there's not some distinction drawn between the two, and guidance is given that if you're not dealing with communications data, that the evaluation of the country's laws and surveillance laws is a different evaluation. I don't know. Logically, I don't think the sector matters, but to try and make this more workable, and there may be some guidance that is sector based. Again, unfortunately, I think it's a case of watch this space.
Yeah, thank you, Joanne. And like you say, I think in terms of the amount of transferring, and obviously the world that we live in, the globalised world, that obviously from all parties, both sides of the Atlantic, and political and legal kind of parties, there is obviously kind of an interest to get a solution to this and have a solution. And I mean, from my perspective, it's probably now, whilst waiting for kind of the watch this space and waiting for the updates, it's probably more important than ever to make sure you've got that data mapping and know where the data is going, and you know where you need to update everything. And obviously that's kind of steps people could be taking in the interim whilst they're waiting to what to put in place. We are 29 minutes past, so I think we probably don't have any time for any further questions. So if we haven't, apologies if we haven't managed to get round to your questions as part of this Q&A, and that we'll be going through. Hopefully, I know some of the questions came up that Joanne helpfully had already kind of been pointed out, or had then worked through while she was discussing. But if we haven't managed to get to one of your questions, then we will try and feed back to you after this webinar. Joanne, shall I just pass over to you for final remarks?
Yeah, that's great, Lauren. I think, as has been said in the Q&A box, it is being recorded and it will be circulated to people that have registered. Thank you very much for coming. If you do have any questions, if you can sort of let us know who you are, we can come back to you, because with anonymous questions we can't. Then we appreciate it's quite a complex topic and a bit of a hot topic, so more than happy if you've got a question, if you let us know who you are. And as I say, thank you very much for attending. I suspect we might do an update once we've got a better idea of what the data protection authorities are saying. And I'll say again what I've said throughout this, unfortunately, watch this space. I think European Data Protection Board, ICO, Irish DPC, I think they'll be hopefully giving us some guidance very quickly, and practical decisions can then be taken by businesses as to where they go from there. But thank you very much for joining us.